you all for joining us for the first of our four-part series on the collaborative practice of law. And at this time, I'd like to turn the webinar over to our panelists.
Hello, everyone. I'm Virginia Miller, and I'm your moderator today. I'm also a collaboratively trained lawyer. I'd like to welcome everybody here to our first collaborative law webinar. And like Eileen has said, we've got several more of these coming up before the end of the year. And so we'd like for you to, if y'all can, join us for all of those. So without further delay, I'd like to introduce our presenters today, Brian Turner and Francis Nolan. They both have had extensive collaborative training. They're very involved in the collaborative community here in Alabama, and they've collaborated together many times over the past years.
Yeah,
we have
pleasure.
Exactly.
So, with that being said, I think our first topic that our presenters are going to talk about and tell us about is what is collaborative law.
Well, good morning. I'm Francis Nolan. I would say that the best definition I like to use for collaborative is that it is a voluntary, consensual, non-adversarial process that is forward-looking, that employs a team of professionals to help a couple restructure their family for the future.
And collaborative, and this is Brian Turner, and thank you all for joining us on this this call today. We're going to be talking about collaborative from the standpoint of a family law practice today, but collaborative does have applications outside of family law, and those may be addressed a little more thoroughly in future webinars. But today we're going to focus more from the standpoint of collaborative divorce practice. So collaborative is a creature both of contract and of statute. And the key thing here in Alabama is that we have the Collaborative Law Act in place to allow this practice. It's a limited scope practice under the Alabama Rules of Professional Conduct, in which the parties are retaining counsel to represent them in structured negotiations. This is not filing a complaint and running down to the courthouse and filing a bunch of motions. This is really a series of structured negotiations to try to help the parties reach the best potential outcome.
And I think the cornerstone of collaboration, I think we're having a snafu with our PowerPoint because I think we got the wrong order on our slides. But the cornerstone of collaborative, and the thing that's most important to point out, is that the contract entered into between the lawyers and the parties stipulates that in the event that the parties are unable to reach resolution, they are required to retain different lawyers to represent them in litigation. The collaboration is intended to give everybody the same goals. Everybody has skin in the game. Everybody's goal is to help the parties reach a resolution. And I think for some people that kind of becomes a deal breaker, because they're used to negotiating from the standpoint of having the threat of litigation looming.
Right, and I don't think you can overstate, or the impact cannot be understated as how important informed consent is. It's required under the Collaborative Law Act that parties be informed as to the rights that they're given by entering into a collaborative process through a participation agreement, which is a contract giving up the rights that they would have to proceed in court. And it's imperative that the clients understand the difference between this path and litigation and other options that they would have in pursuing a divorce.
And Brian, before you move on, this question is to Brian and Francis. How much time do y'all think y'all spend talking about the informed consent part?
A lot.
A lot. And that happens right at the front end in the initial consultation. I know for me that when somebody comes and has a question about collaborative or getting a divorce in general, I make sure that they understand the various paths available to them. Litigation versus just an uncontested divorce versus mediation versus collaborative, and we'll talk about the differences in those. And make sure that they understand if they choose this path, they know what they're getting into on the front end. that this is not something just to say, wow, that sounds like this might be good, let's just go ahead and give it a shot. That you really have to understand what you're getting into.
So, for example, if somebody is looking for a process in which blame is the focus, or some form of punishment is being sought, not your right process. If somebody is looking to keep secrets or to hide some essential aspect of their financial picture from the process, this is not the correct process. I mean, we are assuming that everyone is going to be honest and is going to voluntarily disclose all of the information that's required to make an informed choice. And as collaboratively trained lawyers, it's our job to ensure that our clients are honoring that.
And I know we haven't probably gotten to the slide yet, but is that has something to do with the statute as well, doesn't it? When Brian was saying that he tells his clients about all the other options.
The statute requires that we tell the clients all their options.
Okay.
So one of the questions that I know we get frequently is, when is collaborative appropriate? So Francis, when have you found?
I like to tell people that the best collaborative cases are those where the parties really desire a private cooperative process, but they can't achieve it on their own. In other words, there's not a balance of power or information and knowledge enough for them to sit down at the kitchen table and do it on their own. They really need guidance. They may have communication problems that would prevent them from being able to discuss the thorny issues necessary to reach resolution on their own, but they're really looking to put their children first, or to preserve the relationship, what's left of it, for the future. And those are the people who have the most success in collaboration.
Right, and people who, another key piece is, want to keep things confidential. One of the cornerstones of collaborative is that the process itself is handled confidentially. At the end of the process, when an agreement is reached, then basically an uncontested divorce is filed. But all the making of the sausage, so to speak, is not in the public eye. It's not done in a courtroom. It's not done through motions. It's done in a manner that is confidential and kept confidential. And we'll discuss a little more about how far that confidentiality extends in a minute.
Well, and then the next, we've talked about when it is appropriate. So, Brian, you want to talk about first when it's not appropriate?
Sure. First, the thing that I've stressed to not only clients but also to other professionals, whether they're lawyers or financial planners or mental health professionals, is that it's not for everybody. It takes the right people, the right parties, the right professionals to make this work. Particularly if you've got a client who thinks that they're going to come in and be able to strong-arm their spouse, or is not willing to negotiate good faith, thinking that they can, play games, hide the ball. That case is not going to be appropriate for collaborative if somebody's going to try to move forward, in bad faith.
Francis, do you have anything to add to that? Have you ever seen any certain type of personalities that have been attracted to collaborative that maybe don't need to be in the collaborative process?
I can only think of one case that Brian and I had that just sort of blew up the minute it started, and I think that was really just a clear situation where people were not willing to act in good faith. There was a lot of sort of vengeful, retaliatory conduct that just couldn't be, calmed down. That sort of stuff is not going to work in collaborative.
Right, and the next point that we've pulled up, that if people are unwilling to share relevant information, I think some people come to collaborative thinking, confidential means I don't have to share things that I think I should keep secret. That's the quickest way to blow a collaboration up, is if somebody says, I've got information, but no, I refuse to share it, the process ends. It's just not going to work, whether it's documents, whether it's information about relationships, whether it's anything that's pertinent to making the decisions that these clients are trying to reach in fashioning what their divorce is going to look like, needs to be voluntarily shared.
I I think one thing I would add to that, I think a lot of lawyers have a lot of sort of discomfort around the idea that another lawyer could use this process to gain an upper hand, and, you know, somehow gain an advantage over their client. And I think that's why we don't collaborate with lawyers who are not trained in collaboration.
Right.
You know, there's very good reason why training is critical and essential. And even then, not all lawyers collaborate equally well. So it is sort of there is a learning curve there. There is sort of an educational process and just learning what teams work well together and who you can trust. But in a trusting professional relationship, I never have any doubt that my co-collaborator is going to hold their client's feet to the fire, and there aren't going to be any games being played.
Another area is if the clients aren't able to articulate or represent their own interests. That has been something that I know Francis and I have dealt with in a few cases where, you know, one client or sometimes both are unable to articulate what it is that they want, they need, that, you know, has to be addressed. And this is very much a client-driven process. This is really trying to, you know, one of the analogies we use is that in litigation, counsel is very often standing in front of their client with a sword and a shield. In collaboration, we're either standing next to them, holding their hand, helping them reach their goals, or standing behind them and helping them move forward. And if the client's unwilling or unable to identify their interests and their needs, it makes for a very difficult process.
Yeah, the client who wants you to make all the decisions for them is not really
that's not for here. Two other areas that I think are critical about determining which cases are appropriate. If there's a history of physical or severe emotional abuse, the balance of power is so out of whack coming into that, that, you know, in the cycle of just where people are mental health wise, it makes it almost impossible to handle collaboratively. And another is if there's active mental illness or untreated mental illness or addiction, can be a real deal breaker. If you can't have somebody who can work within the process because they've got one of these issues that remains untreated, it's almost impossible.
But we have had treated
absolutely
mental health
and substance issues.
Yeah,
sure. It's when something is not treated and you can't rely on the person to participate actively that it makes it near impossible.
Well, the next, then we're moving on to the next, and probably what I think everybody really wants to know is what's the difference between litigation and the collaborative process. Francis, do you want to start with that one?
Well, I think the biggest difference and this may be why divorce is the area that collaboration has had the most success. The real difference is this is a forward-focused process. It's interest-driven. It is, you know, in litigation, we spend a lot of time looking back, trying to understand what happened, how did it break, whose fault is it? And we don't, I mean, obviously that has to be dealt with, but that's not our focus. Our focus is on the future, on the goals of the parties, on their interests, and on building an outcome that they feel like matches their goals and interests.
Right. We're not trying to, you know, assess blame, and we obviously in a matrimonial practice, those things are going to come up, and we're going to deal with them through the team that we're working with, so that the parties are in a position to make decisions, because we're not asking a judge, you know, to rule here. We're, you know, not going, you know, this is the parties have to be able to get to the end result. And the difference between interspace and positional negotiations, in interspace negotiation, you know, you're really trying to get to not the what that the client wants, but the why. And in a very thumbnail sketch, it's very easy for the client to say, well, I want the house, and dig their heels in. And in litigation, well, hey, my client wants the house, so we're going to fight for the house. When you sit down and try to get to the why, well, the why behind why they want the house may be that they don't want to change school districts, that they don't want to, you know, cause too much disruption for their children from their friends. They may feel that that is the stability that they need to know that they've got stable housing. When you get to the why, there may be other ways, though, to meet those goals that may not be that house. So if you can, you can get to the reason why they want whatever it is they're asking for, you may be able to help them find other ways to achieve that goal as opposed to just digging your heels in on the what.
I think one really cool thing about collaborative is that when we talk about the law and the role of the law as it relates to the facts in the case, we do it in a transparent meeting where both lawyers are present, both parties are present, and everybody hears both lawyers' perspective so that there's not this sort of, hush-hush, nobody knows what anybody else is saying sort of discussion about the law's application. And then, for the most part, in our experience, people just move on. They're not real concerned with what the law requires. They're much more interested in negotiating what they want to have for their future, which they have certainly the freedom to do.
Right. We have to remind clients that, we are working in a legal process, that it doesn't work in a vacuum. It's not like we're taking, case law and the Alabama Code and tossing them out the window. We're not. But we're using the law as the measuring stick against which the decisions they need to make fit. We're not saying that law does not apply, but we're having honest and upfront and transparent discussions with them about how the law is applied, how we've seen the law applied, how we've seen different situations work or different judges rule, so that they have all the tools in front of them to make the decisions they need to make. And the word confidential is back up here again. And the way confidentiality works as opposed to litigation. In litigation, obviously, unless a case is filed under seal, everything's public record. There's motions, there's hearings, everything's depositions. Here, everything is basically kept in a bubble inside that process. And part of what you're agreeing to in that participation agreement is if the process doesn't end in the agreement that you're hoping for and the process breaks down, all of the work product remains with the professionals who created it. You're starting over at square one. The professionals are protected from having to come give testimony. Their files are protected from from being discoverable. That outside, certainly documents that the clients have, tax returns, credit card statements, photographs that they've brought in, those things go back to the client. Those are theirs. They can certainly be used in a litigated process. But the work product of the team that has gotten them through the process or into the process, that remains in the process, and that is non-discoverable. So the parties are understanding and signing that participation agreement that they realize, if this does not work out, they go back to square one with new lawyers, and everything that's been said is kept in the process. So that also gives them the ability to speak frankly and speak openly. This is not a way to get free discovery on somebody that, we'll try the collaborative process, get all their secrets, and then we're going to run out. The idea is that it's all protected.
Well, your next.
Have we talked about the fiscal efficiency?
Not yet.
Okay.
We're getting
Okay.
there. We're getting there. I wanted to bring up that y'all talked a little bit about the other professionals involved, and that is a difference in the process. Can both of y'all speak to the benefit of having these financial and mental health professionals involved in the process?
Well, I certainly appreciate the involvement of a neutral financial whose job it is to marshal all the financial information, because that's probably my least favorite part of my job in the other paradigm. I really enjoy having somebody whose expertise is numbers. I like the fact that my client is able to make an informed choice that involves a projection of what each option might represent for them as, year 5 out from the divorce, year 7, year 12. I like the fact that better information is available to my client. And I like the fact, and I guess this loops in fiscal efficiency, I like the fact that we're not duplicating efforts. All the information is produced one time in one concerted effort to collect the information that's needed. by the financial person, so we're not duplicating efforts. And then obviously the mental health professionals, without them, we would be lost. They help the lawyers, they help the parties, they help with communication, they help with all of the parts of getting divorced that are just inherently hard, that we can't make easy.
So you're saying there's only one financial professional?
There's only one financial professional. I guess you could have more than one if
you need be. We needed somebody to do an assessment or evaluation. That would be a neutral expert that we would
bring in. Both sides don't each get.
No.
Okay.
And what works great with that is, like Francis was saying, as lawyers, we like to think we wear all the hats and we like to be in control of all parts and think that we can do it all. But to have the right professional doing the right work and then creating the right work product streamlines it for us. So, one of the things that we hear about, and I'll get back to the mental health professionals in a moment, when talking about fiscally efficient, not everybody who's on the team is in every meeting. The work is done by the right professional in the right meeting. So if it's a meeting that the parties are going to have with a financial neutral to go over budgets, the lawyers aren't sitting there with them. They're only people involved in that meeting are the clients and that financial professional. Now, when the financial professional has all the information and is ready to share it with us, so we can start looking at options to handle the distribution of the marital estate, then the lawyers get involved in the meeting. The mental health professionals, when people hear that there are psychologists involved in cases, they think, oh, we're doing counseling, we're doing marriage counseling, or this touchy-feely. No. These professionals are there to help guide communication. They're there to, as I said, get past the landmines. And I think they coach me more often than they coach my client in ways of saying, okay, this is a hot button issue for these people. Don't go barreling into it head first. Come around the side. They're there to help steer through the communication hurdles and to help build trust. By the time people get to divorce lawyers, they often don't trust their spouse. This is not to save the marriage or anything other, but to create trust in the process. And then also hopefully give them, if there's children involved, especially a stepping stone for moving forward as co-parents, which is very, very difficult work. And I think they play a tremendous role in helping us shape parenting plans and get through the muck, particularly early on in the divorce. But again, those meetings that the parties are having with their coaches and doing all this work, Francis and I aren't sitting there. They're not being billed for 4 or 5 professionals. They're only people who are involved are the people who need to be there doing the work they need to do. And when their work is done, they drop out. And it eventually funnels back down to Francis and I, and hopefully, an outcome has been reached that the clients are happy with, and has been far less expensive than litigating and a drug-out process over an 18-month or longer period to get to a trial date.
I think when you see the word win-win outcome, most people would probably roll their eyes and think, that's not possible. You got a pie, you're dividing it in half. How can that be a win-win for anybody? I think this goes back to the difference between bargaining positions and having an interest-focused process. Because often what we find is that one person wants the orange peel and one person wants the juice. And so if we can divide the orange accordingly, then we have a win-win resolution. And I think that is possible more often than we realize.
Right. When thinking about dividing that pie in half, it doesn't mean that all the pieces come from one side of the pie.
Mm-mm.
That if you got your half of the pie, but 2 pieces came from one side and 3 from the other, it's still half the pie. It's just figuring out which pieces fit what you need.
Mm-hmm.
Go ahead.
Oh, no, I didn't want to interrupt you. I just know talking about all of these professionals involved, even though they're not all together at the meetings with everyone, probably has some folks listening questioning how that might be fiscally efficient.
Well, the people who are employed as coaches are doing what they're trained to do, generally at an hourly rate that is lower than a lawyer's. I don't know about most of the people listening, but I know as a lawyer, anytime I'm in the other paradigm, I spend a lot of time doing what I think coaches could do better than I do it at a much higher hourly rate. Likewise with financial neutral. So lawyers' rates are generally higher than anybody else involved in the process. And when you're paying people to do what they are uniquely skilled and trained to do at a lower hourly rate most of the time, then it leads to a more fiscally efficient outcome, not irresponsible, responsible. And even though the expenditures are sort of heavy at the front end in collaborative, they tend to taper off towards the end, where litigation tends to be the opposite, sort of an upside down
pyramid
graph of that. You tend to spend less at the beginning and a lot more as you progress.
Sure.
Right. Whereas in collaborative, there is more upfront expense, but it tapers off, and there are statistics available through the various collaborative organizations that have done studies on the cases that are out there that show across the board collaborative proves to be more fiscally responsible and efficient. The other piece also, like with the financial planner that we mentioned, whether it's an accountant or whether it's a financial planner or whomever we need to do the financial neutral work, one, just by saying that, you're getting the right person for what you need, but you're not hiring two experts to battle it out. In a complex, financial picture, if that's the case that you have, having one person do that work and break it down into bite-sized pieces is worth every dollar you're paying, and that dollar is usually a lot less expensive than the hourly rate of the lawyer, or paying two people to do it and then have to battle it out to see who's a judge is going to side with.
Okay. I think everybody's next question at this point might be, they may be thinking, this kind of sounds a lot like mediation. So, Brian, Francis, y'all want to discuss how this is different from mediation?
People always want to assume that this is mediation, or the other most common assumption I have when I talk about this to people, not lawyers, but is, so we just have one lawyer. That's what collaborative is. We just have one lawyer. Like, no, you can't have one lawyer. That's not ethical. So, but mediation is not, it's not, one neutral and two parties with their lawyers. It is two lawyers and two parties acting in a manner that would be more consistent with the attitude of mediation, I guess. But it's structurally very different.
Structurally different, maybe a hybrid in theoretical application.
Right.
Because in mediation, hopefully you're shooting to try to get to interest-based discussions. So you carry that piece from mediation into the process. But again, you don't have that neutral third party running back and forth playing, shuttle diplomacy and carrying the offers. You're sitting around the table, having those conversations directly.
And every time a statement is removed, so I say something to you in a closed room, you leave the closed room, take what you heard, say it to another person.
Yeah, it's like playing telephone games sometimes in mediation.
Yeah. It's like the message is lost.
Well, and the other thing in mediation, and as a mediator, I tell clients this all the time, if you say it in the room with me or you and your attorney, it's confidential. If you say you may not share that, I may not share that. In collaborative, we're sharing everything. Also, I will mediate for pro se couples. Obviously I can't give legal advice in that situation. If they come to a legal question, I have to tell them we need to take a break. You need to go call a lawyer because I can't give you specific legal advice. In collaborative, absolutely, there's advice being given, even though the field may have a more mediation type feel to what we're doing.
Brian, and this is we're about to get into how the process works in just a minute. We're going to get into that. You just said something though that I think probably maybe perked up everybody's ears when you said, as a mediator, I don't share everything, but in collaboration, we're sharing everything.
Correct.
So can you talk about that, what that really means? And because there is privilege in collaborative. Absolutely.
Privilege still exists. So, if I'm having a meeting with my client and they say, hey, a bank account that I've not disclosed, I'm going to tell them we need to disclose that because that's what we've agreed to do in the collaborative process. If they say, no, I'm not going to disclose that, I need to let the other professionals know the process is over. That I have to get out, and I have to get out for reasons, not because my mom's sick and I have to go out of state to go take care of her, but I've got to get out of this case, which sends up a red flag that, there's an issue there. In mediation, as the mediator, if I'm in, a caucus and a party says, well, I've got this other bank account. And I say, well, I feel like we should share that with the other side. And they say, no, I can't share it. I am ethically bound to not share it. So that is a big difference.
But in collaborative, you do have some opportunity to have privileged conversation with your client about non-substantive things.
Correct.
Like, let's say my client comes to me and wants to talk about being upset about some circumstances that went down at the marital residence with the kids, just needs to vent, but says, I really don't want you to talk about this. Well,
Yeah.
It's non-substantive. It's sort of their choice at that point.
Right. Anything substantive has to be shared.
Right.
And that's, again, with that participation agreement and that informed consent up front, that the clients need to be aware that this is what they're signing up for, is that they're going to, be sharing all this information.
Have we touched on that? We've probably discussed everything about the differences at this point.
But pretty close. Now, one area, and I have to be cognizant of this when mediating too, is that parties often feel that they're giving up power to the mediator when they're there. I can tell them till I'm blue in the face, I'm not here to make decisions, but they're looking to the mediator for some form of guidance in the negotiations, and they feel like they're giving something up. The negotiation table at collaborative, that's not the case. The parties are not giving up power to somebody else to negotiate for them or to give their message for them. And again, we've touched on the number of professionals in reaching resolution, and that the parties are expected to make contributions themselves. The mediator's not carrying that message for you. You've got to speak up for yourself.
So, after hearing the differences, and I bet everybody's wondering, how does this really work? If you're not going to a courthouse, how does this really work? Francis, do you want to start off with trying to explain to everyone how this actually works?
Well, the first step in the process is to sign a fairly lengthy document called a participation agreement. A participation agreement is essentially that cornerstone contract that establishes the rules of the game. It covers a lot of ground. It talks about the requirement to retain different lawyers if your collaboration failed. It talks about the need for voluntary and full disclosure. It talks about maintaining the status quo until resolution is reached so that people have some degree of comfort about their financial situation. It talks about the need to be respectful in communication. So it's a very lengthy document. We tend to go over it in a lot of detail. And that's kind of step one. Brian and I have done it both ways. We've had the participation agreement signed just by the parties and us in an initial meeting where we go over it. And we've also had the whole team present and participate in that.
That's the other thing, that we have the flexibility of figuring out what works for each situation. So if it's better to have the clients come in and go through this with just the lawyers, fantastic. We can do that. Then the professionals that they meet with who are playing other roles can sign on later. Sometimes it's great to have everybody in the room together so everybody can eyeball one another and see who's going to be working with whom and get a feel for what this is going to be like to see this team in action together. Mm-hmm. Because it is very different than anything else.
Now, let me ask you this question. I don't mean to interrupt you, but I think, how do you decide where to meet? Where do you meet, and how do you decide where to meet?
What's most convenient? And usually it's convenience for the parties. Plus, who's got the biggest conference room?
So y'all are saying y'all meet at somebody's office.
Right.
Oh, yeah.
Okay.
Yeah.
And we either rotate as meetings progress, or, Brian's office is in Homewood, mine's downtown. If somebody works downtown might be more convenient. If nobody works anywhere near downtown, we might have all our meetings at Brian's office.
Different financial professionals we use have technology. If we need to use, a big screen for something, we're going to their office where we can put it up where everybody can see it.
So it doesn't have to be at the lawyer's office.
Does not have to be at the lawyer's office.
All right.
Again, it's client driven. What works for the client?
We've covered all of
I think we've covered some of these other points about, again, make sure everybody understands good faith and that, you're using counsel who's trained in handling these things. And
No, I kind of have a question. My next question would be, so once you get to the meeting, how do you get started?
Well, and once we have everything in place, and again, we're going to touch through some of these talked about, the mental health professionals and financial professionals or other experts. I think Francis used this term first, and I think it's the right description of it. This is choreographed negotiations, choreographed conversations.
Right. Yeah, I think usually the two lawyers have had a conversation prior to the meeting. They are starting to get to know their clients, starting to get to know the dynamics of the parties, starting to understand where the soft spots or trigger points are. And so we may be very intentional about where we make people sit. We may be very intentional about what sorts of things we avoid talking about at that first meeting.
Or where we meet.
But we're always going to have an agenda. Every meeting is going to be agenda driven. The parties are going to have had some input in the agenda except at that very first meeting, which generally is driven by our agenda to just get them on the tracks, get the train on the tracks. In collaboration, one of the very first things that we deal with are temporary issues. Usually the parties want to separate as soon as possible and want to do that in as effective and amicable way as possible after telling the children. So if that is an issue for people, that may be on that first agenda and that may be driven by them. But other than that, it's going to be sort of introductions, and we're going to talk about sort of the importance of some of those cornerstone pieces of collaboration. We're going to go through the participation agreement in detail. We're going to ask if they have any questions, deal with maybe some temporary issues, and then we're going to talk about what's up next.
Right, and
then
then
give them a roadmap.
And we never leave a meeting without having the next meeting set, whether that meeting is with us or whether it's with the other team members, the financial person, the coaches, and if there's homework. Now, we try to set an agenda for the next meeting, and if something comes up in the interim and the client says, hey, we had an unexpected expense that we don't know how to meet, guess what's going on the agenda? Clients call and say, hey, we were supposed to get these records for you, but we've had a problem with our bank finding the records. We don't have them. Okay, we can adjust to that. We also take minutes. So one of the things we like to do is if the meeting's at Francis's office, I'm responsible for taking minutes, and vice versa, or we'll trade that off. And after the meeting, the minutes are circulated. And this is very much just a straight out of the business world model. Everybody gets to review them, correct them, so that there is a record of what was said, what everybody agreed that they were going to do, what the next steps were going to be, and that builds in accountability so that we can go back and when somebody hasn't done their part, we can say, well, at that meeting last Tuesday, you said you would provide X, and you hold their feet to the fire. This process only moves as fast as the slowest wheel because we're not under a scheduling order. We're not under, court deadlines. But as protectors of the process, we also have a duty to keep the process moving forward. So we had a case that blew up a few years ago where we were pretty well into the negotiations, had a good number of things that we felt like we were agreeing upon, and one of the clients decided they were going to get in their RV and go travel for 6 months and, try to stall the process. Well, that case ended up in litigation, and I think they litigated for about a year after several months of working with us first. Our obligation is to try to keep the ball rolling. But very frequently, people come to our office, and I assume, Francis, you run the same thing. One wants a divorce, the other one's not quite caught up to that point yet. And this is a little bit, playing emotional catch-up. We're not going to jam this person into a hearing. We're not going to say, you have to sit down at the mediation table next week. We're going to be cognizant of the needs of the parties. Emotionally as well as the financial needs, and take that into setting meetings and trying to bring people along and figuring out what's the best steps to meet the needs of these specific parties, and it can be different in each case.
It's a balance of honoring where people are and keeping them moving. Sometimes you're hand-holding and sometimes you're pushing. Hopefully there's a balance so that nothing really gets stalled.
And also, I had another question about So just to be clear, everyone, both the parties and the professionals involved in the meeting, all have a say in the agenda. Is that accurate? Is that accurate?
Whoever's going to be in the meeting,
Right.
or if it's going to be something prickly, we might have input from somebody who's not going to be at the meeting. And let me just say, like any process, collaboration is a relatively new idea. We're constantly working in our practice to make it more efficient and more make it flow more smoothly. And so one of the things that we have started trying to do is draft minutes in the meeting and have them signed off on in the meeting so that it's not an extra step.
Right. And people's memories, often if you wait a day or two to circulate something, I don't remember saying that. Well, this is what all of our notes had.
Right.
And you agreed to it on the spot, we're more likely to be able to hold that.
Right.
The goal being that, once all the pieces have been addressed, parties have developed a parenting plan, usually through the help of the coaches. We've worked with financial neutral and come to a conclusion. When I say coming to a conclusion with the financial neutral, that will be a series of meetings as well where we talk about, what does this look like, down the road. And this is one of the coolest parts, I think, of collaboratives, to sit there and have the parties' actual budgets up and their financial resources on a whiteboard or on a video screen in front of you, and to be able to move the pieces around and say, okay, well, if we transfer asset A to the husband and his expenses look like, here's when he gets to a point where he's going to have to dip into that. Or, based on spouse A versus spouse B tax bracket, this asset makes more sense to go into their pile, and be able to actually generate out, this is what this potentially could look like for you based on the information that we've got here 5 years from now, 10 years from now, 20 years from now, so that they're making an informed choice as to what they want to do with dividing their marital estate. Once we have all that information, then Francis and I sit down and we're drafting, a settlement agreement that looks like every other uncontested divorce that gets filed. And that's the first time when the court gets involved. At that point, a complaint for divorce is filed, and an uncontested divorce is going forward, and hopefully the parties feel that they've reached something that they can live with and is in the best interest of their family.
How do you get the parties talking in a meeting? Have y'all already met with them previously and helped them generate options for
part of the choreography once you get rolling is for each client to feel prepared for what's coming next. So you will have sat with them and helped them to understand what's going to be discussed, help them to find their voice and the words to express whatever things are going to come up in that meeting.
Those coaches are fantastic at that. That's where the mental health professionals, particularly if it's a touchy issue, can help the clients find the words and help the lawyers know how to help them find the words when we're in the meeting.
And quickly, have y'all ever had a situation? I mean, obviously the clients are prepared when they get to the meeting. They know what the meeting's going to be about. But what happens? Do you ever get any pushback or negative reactions in the meeting?
Oh yeah.
Yeah.
This isn't easy.
One time, Brian and I had a case where we were sitting in a little tiny conference room at his office, a little bitty round table, barely room for 4 chairs around the table, and the clients were screaming at each other.
We got through it.
Yeah, sometimes people just have to get it off their chest. I mean, for the most part, we want to try to restrain people from that sort of conduct, but every now and then, you just...
This is emotional.
Yeah.
Emotion doesn't get checked at the door.
And what y'all are saying is this isn't always comfortable.
Oh, no.
And
No,
more often than not uncomfortable.
And this is not easy by any stretch of the imagination. It is hard because you're in a paradigm that you're not accustomed to. It's a different way of thinking about conflict and resolution. It's a different way of guiding clients, and it's new for them too.
And as matrimonial lawyers, we're dealing with the most intimate parts of people's lives. We're dealing with their homes, their financial security, their children, their, whatever broke down the issues in the marriage, trust. Maybe there's infidelity. I mean, we are touching the parts that the average person that they're talking to throughout their day never sees. It's going to get hot. It's going to get ugly. It's going to get difficult. But when you've got people involved that are agreeing to be transparent about this, and you've got those mental health professionals there to help you figure out how to have those conversations, and you've got a trained financial professional there to say, you really can't afford to spend, on, continue to spend the way you've been spending, and you've now got $60,000 worth of credit card bills. You can reach a far better outcome than just, coming in and saying, well, heck, let's let the judge decide.
Have we covered all our slides? I know we need to give people a chance to ask questions.
I believe we
think
have.
we need to, I thought, were we going to talk for just a minute about where to get some training, or were we just?
I think there may be a slide or something.
Yeah, and if there's questions, this may be a good time to have them, and then we can get to some of those as well.
All right.
So,
Eileen?
or if there are any questions anybody would like to ask.
Well, this is Eileen, and we did have a question submitted to the chat that says, does each party have their own coach? Can you address that?
Yes, we will. Very good question. Maybe.
Sometimes yes.
Sometimes no.
Yeah.
More
Depends
often
on the case.
more often than not, I think we have worked in a two-coach situation. But we've also had people come to us that want to work collaboratively that maybe don't have quite as many emotional hot buttons or hot topics to hit, and we're looking at somebody just to help draft a parenting plan.
Well, Virginia and I had a very successful case where we only had one coach, and I don't really know what drove that decision. It wasn't like the parties didn't have conflict or issues, but it worked beautifully.
And it may be a financial consideration.
Yeah.
And if that's the case too, we'll be cognizant of that. I will say that almost 10 times out of 10, the parties who say, now we don't need the coaches and let's go ahead and try to hammer this out without the coaches,
Never.
We end up getting the coaches in eventually, and it's a longer process, a more expensive process. If we get them involved, because people hear coach and they hear mental health professional and they think, oh, that feels icky. I didn't want to talk to a counselor before. Why do I want to talk to somebody like that now? But I think we have found if we get them involved at the get-go, the process is faster, smoother, more efficient, and costs less.
I had a question.
Yes.
What happens when your clients don't follow the participation agreement?
In what way? What are you talking about?
And does it speed up the process?
Oh, no.
Does it slow down the process? What happens when people are not being their highest and best selves in this process?
Oh, you mean all the time?
All the time.
Yeah. Are you your highest and best self all the time? I don't think it's humanly possible for anybody to be their highest and best self all the time. So we're constantly navigating around the bumps in the road, and that's going to happen. It's not a question of if. It's just
a matter of
when. Yeah.
Yeah, and if it's egregious enough, the process can terminate. If parties decide, I can go back to that. I've got that bank account. No, I'm not going to disclose it. Even though I've signed this participation agreement saying I would, the process is going to end. They're going to start over at square one with new lawyers and end up in court.
But that's really rare.
Yeah.
Really, what we see more often is just people
Getting angry
or I mean, it's a learning curve for the clients too. Let's remember. I mean, we don't live in a culture really, especially not today, that encourages people to communicate respectfully.
Right.
So there's a steep learning curve for everybody. So.
And to jump back real quick, I meant to mention this. I know that jump back about whether you have a one coach or a two coach model. There's some practice groups that practice solely with a one coach model.
That's right. Texas
Absolutely.
uses one coach.
And
California won't do it without two.
And each practice group thinks the other one's probably crazy for doing
Yeah.
it the other way. But here we sort
we-
of open.
We adapt to what is the best for the clients.
The needs of the parties.
But we have learned we don't do it without at least one.
Right.
Right. Right. Any more questions, Eileen?
Yes, we have a few more questions, and we have plenty of time, I think, for them.
Okay.
One question is, what percentage of your practice is collaborative?
Not nearly enough.
That was about what I was going to say. It's getting to be more collaborative is fairly new to Alabama. Only within the last,
2011
or so, I was going to say 7 or 8 years. Although it's been around a little longer than that nationally, and it's catching on. So the more that clients that we've had, the more that I find, hey, Mr. So-and-so said they went through this process, they referred me to you. I don't know that I've sat down and actually broken down what percentage of my practice it is.
Well, let's put it this way. Since 2011, I think I've participated in 25 collaborative divorces.
Yeah, and
in that time, I have probably been, I don't know, hundreds. I don't know. So it's small.
It's a smaller percentage, but I will say this: it is the part of my practice one of the parts of my practice outside of mediation that I find most rewarding, and I find that I'm most effective in, and that I'm getting the best results from. I don't go home and complain about my collaborative day as much as I do the days that I've been stuck at the courthouse all day.
And I thank you for mentioning that, Brian, because I was going to ask how the job satisfaction felt with regard to collaborative, and I think all of us can agree that it's pretty high.
I think so. Yeah.
Especially as we've gotten more experienced.
Right.
What's the next question, Eileen?
Other than divorces, what other areas of law has collaborative law practice been successful?
Go ahead.
No, you go ahead, Brian.
I've heard of successful cases in the area of probate. Again, touching on the things that we said at the beginning about, where parties may have a relationship that they want to preserve. Business areas, I think, have had some success. I've heard of cases in the world of medical malpractice.
North Carolina.
Yeah.
That has practice groups that are starting to do medical malpractice cases collaboratively. I understand that some of the hospitals, when you sign in at the hospitals, hospitals opt in from the beginning to potentially the collaborative process.
Yeah.
Construction law, not to throw his name out there, but Oscar Price has been trained here in Birmingham. So for anybody who has any construction law cases and wants to be collaborative, call Oscar.
Sure. It really, the key is that preservation of relationship. This is not an area where, a car wreck doesn't necessarily fit well. But it's, again, an area where the business world, I think it's just a matter of time before it catches up. Particularly if you're trying to keep a business relationship. And that's, I think, the cornerstone is there's something here, whether it's the confidentiality or the preservation of a relationship, that's going to drive people to this process.
Next question, Eileen.
Okay, we have another question that talks about or asks about the average cost. If employing mental health professionals, CPAs, and coaches with lawyers, who can afford this if it doesn't work out?
I think the International Academy of Collaborative Professionals has done a study over the course of several years that was published several years back. I believe the average was somewhere around, was it like $25,000, I think, all in. Our experience, I think our local experience, well, I think we have had, probably my most expensive collaborative case was maybe $80,000, and that was all in.
And those were cases
that's all the professionals.
Yeah, that's everybody's time.
And that would have been just the lawyer's fee in the litigation of that case. That was experts, business valuations, all of that kind of stuff.
Right.
So,
and you hear, and so, it does take resources. There's no question that this is an area that involves, I can see where maybe if there was this is kind of a brainstorming thing, a pro bono practice group that took on the occasional, pro bono case, if you had the professionals who all said, yes, we'll volunteer X number of hours. But I've certainly seen litigation bills that far dwarf my most expensive collaborative cases. and we've had far less satisfactory outcomes.
I think when we first started collaborating, we tried to sell it as, cost effective. And I think over the course of time, as I've done more collaboration and I've talked about it more, my focus is not on, oh, this is cheap. Y'all need to do this because it's cheap.
Yeah.
It's more about what process do you seek? What kind of outcome are you looking for? If there's no question that the well-heeled are better suited often to wanting a private process. They have more at stake. They have more to lose in litigation. They don't want their accountant to be deposed, for example. They don't want their business valuation to be part of public record.
I think the term that we've used today, fiscally efficient, is the right term for it. It's not that it's super
not cheap.
It's not cheap. It's not the most expensive from point A to point B. But I without trying to sound too much like a salesman, I think this is the area you're getting the most bang for your buck because you've got the professionals who know what they're doing what they do at their hourly rate. And I think that study that you were mentioning has shown that the outcomes are less expensive than a fully litigated, tried divorce case.
Eileen, you have any more questions from the crowd?
Sure, we've got just two more, and this may tie in with what you've just explained, Brian. The question was, is this process more for clients with large estates, assets, and/or investments?
I have handled cases where I would say the clients certainly did not fall into that category. I've had people who were straight W-2 middle-class wage earners that wanted the best outcome for their kids and for custody. I've had cases where there have been significant estates involved and that there were no kids involved. I think it's just how the parties coming into it want to apply the resources they have available to them. Again, you could have people come into a litigated case and spend easily what they're going to spend in collaborative and have a result that they're not as satisfied with. But it depends on the needs of the particular case. You may have a case where there's a significantly large estate, but the issues aren't very complicated and we're done in less than we would have spent on a case with far fewer assets. It varies. I have found cases.
Yeah, I can say the exact same thing. I've had normal W-2 wage earners, and we've had a lot of doctors and professors, lawyers, professionals as part of the process. So I don't think it has to be a high asset case. I do think I saw an article on Facebook today that I thought was interesting about the fact that people with estates of $5 million or more are more likely to have an amicable divorce process. And I don't know why that's true. It seems like the less you have to fight about, the more likely you are to fight. I don't know. But so there's some degree of that going on. It's like people with a lot of stuff don't want a public process.
Well, and I found that the other thing is people who have more emotional capital as opposed to fiscal capital very often turn this way. They're the ones who, don't. I will say the majority of people who walk in my door, one of the first things they say is, I don't want to go to court. How can we handle this where I do not have to go to court? This is one of those tools. And if it's important enough for them to be outside of that process, then those are the ones who are going to be successful.
Right.
Okay, Eileen, I think we've got one last question from the crowd.
Okay. Give me just a second to get to the question. Once the final decision is made or an agreement is reached, how is it filed with the court, or what gets filed with the court?
Just like an uncontested divorce.
Right. Same paperwork as an uncontested divorce. Unlike mediation, this is one area where, again, I'll throw a difference. As a mediator, if clients don't have lawyers, the mediator cannot prepare paperwork on behalf of either one of them for filing. Here, you've got two lawyers. Each party as a lawyer. We're drafting, we're sending drafts back and forth. We may argue about the language each one of us likes to include in the document, but we're drafting, basically the same package that of documents is going to be in any uncontested divorce.
Eileen,
Great. Well, thank you. Well, I think we've reached our time, and I know that we could go on for another hour or so on this, but thank goodness we've got another webinar scheduled for September 21st, and we're looking forward to that, and we hope that you all can join us. I'd love to thank the panel, Virginia, Brian, and Francis, for doing a great job. This is very informative and enjoyable, and you made it easy to digest. Very grateful to our sponsors, the Birmingham Collaborative Alliance and the Birmingham Bar Association Collaborative Law Committee and the Dispute Resolution, this section of the State Bar, for helping to put this on. As I mentioned before, to get CLE credit, you need to complete the program evaluation on SurveyMonkey. The link was sent to you with the invitation. You will need to enter code 5042. That code is 5042 when it asks you for that in the survey. We have recorded today's webinar, and it will be posted on the center's website. And also, the slides will be made available to our participants today, so those will be sent to you by email early next week. And panelists, any closing comments?
The only thing I was going to say is in those slides, there are resources towards the end of, there's some statutory language and the applicable rules of professional conduct. I'm flipping through the screen real quickly here if people are still looking. But there are also resources at the end where you can get more information and more training. So take a look at those if you have more questions.
And you're always welcome to call any of us or email any of us directly. We'll be happy to talk to you.
Exactly. Thank y'all so much for being here with us today.
Thank you, panelists, and thank you all for attending, and this will conclude our webinar. Thank you.
Thank you. This is the old, these are the slides from before we reorganized them.
God.